As provinces crack down on illegal unpaid internships, it's vital that HR managers understand the rules and take the time to assess their programs. That's today's topic on HRM TV. The rules regulating unpaid internships are stricter than you might think. What are some of the most common mistakes organizations are making?
Well, first you should know that there's a distinction drawn in the law between co-op programs and internships. A co-op program, as we define it, typically means a work placement that is unpaid but associated with a school program, such as a university or college program. If these work placements are approved by the ministry, and if they're the objective of the work program is to pass a course or to achieve credit on the way to a diploma, then those work placements are fine. An internship, on the other hand, is not necessarily tied to a university or college program. And in these cases, in order for it to be legal and not to run afoul of the law, and by that I mean to not pay the person participating in the program, a number of criteria have to be met. First, the training that is provided as part of the program must be similar to that provided by a vocational school. Next, the training has to be for the benefit of the intern. The next criteria is that the employer can only benefit minimally, if at all, from the work or the activities that the intern provides. The intern is not allowed to displace a paid employee. There can be no promise of a job at the end of the internship. And finally, the intern has to be advised in advance that he or she will not receive pay as part of the internship program.
The issue is complicated by the fact that the Employment Standards Act does not define co-op or intern. Employers may think calling a position an internship is sufficient, but as we've heard, that's not the case. If an internship does not meet the criteria, that individual would be considered an employee, entitled to minimum wage, vacation and holiday pay, and even termination pay under some circumstances. So what should HR do? We
highly recommend to employers who have existing internship programs that they review their programs and consider those criteria I mentioned earlier. If even one of the criteria that I mentioned is not met, their program will run afoul of the Employment Standards Act and they could face organizational liability. We also would recommend to employers that they consider limiting their internship programs to those that are more in the nature of a co-op program that is affiliated with a university or college, because it's just simply much easier to meet that criteria under the Act.